Okay, welcome everyone. Thanks for joining us at the Firearms Research Center's virtual seminar number 15. As many of you know, looking at some of the names here, we do one of these seminars, many of them for CLE, as this one is, about once a month, on various topics related to firearms and firearms law. Our mission here is to educate the public and share as much information about the topic as we can. And our seminar series is one way in which we do that. With us today are two folks who have spent many decades working in the Second Amendment space in litigation, serving as an expert and as scholars. Don Kilmer is an attorney. He's in Idaho right now. He's been litigating Second Amendment cases for decades, many decades, before the Second Amendment was really the big thing that it is now, the big fascinating area of law that it is now. And Clayton Cramer has been writing in this space for equally long. Both of them are in what you might call the first generation of Second Amendment attorneys and scholars. Clayton is a historian and focuses on the history surrounding the Second Amendment, which many of you know is critically important after District of Columbia versus Heller, McDonald v. City of Chicago, um, and New York State Rifle and Pistol Association versus Bruen, and of course, US v. Rahimi. Um, we will, per our usual format, d- oh, excuse me, Don and will give his presentation, and Clayton is here because he's an expert witness in many cases. That's something he does a lot of. The presentation will be on expert opinion testimony and Second Amendment litigation, as you can see. In a moment, I'll turn it over to Don. With Clayton's help, he'll talk about the topic, and then near the end, we'll do Q&A. You should put your questions into the Q&A feature on Zoom, and then at the end, I'll relay those to Don and Clayton. And with that, Don, Clayton, welcome. Don, go ahead. It's all you.
Thank you.
Thank you for the introduction, George. I appreciate it. As George kind of noted, I've been doing Second Amendment litigation back since the time when you risked being sanctioned by the court for raising frivolous arguments that the Second Amendment even meant anything. So I'll refrain from um, going into ancient history. But one of the things that we ran into as we developed Second Amendment litigation practices, strategies, and tactics, is we kept bumping into how to present evidence in a case for an amendment that seems so clear to some people, shall not be infringed, and so opaque to others, even if that opaqueness was in good faith. So even after Heller, we kept running into judges who wanted to shoehorn the Second Amendment into a kind of a due process analysis with tiered scrutiny, or a First Amendment analysis, also using a tiered scrutiny approach. And surprise, surprise, um, you know, too often courts were relegating the Second Amendment to a kind of a second class status, and using only intermediate scrutiny to take a look at challenged laws. So I started using the term, especially after Heller, well, only after Heller, and Justice Breyer's dissenting opinion in Heller, where he was specifically urging intermediate scrutiny for all Second Amendment cases. I said, no, that's a Breyer patch. Okay. And of course, I was referring to the Breyer patch from the Disney cartoon, but given the homonym of Justice Breyer's last name, it came to be known among, at least among my friends, and probably to their annoyance, as no, though that's a Breyer patch. You want to stay away from trying to adjudicate facts. You need to present your case on undisputed facts as much as possible and argue only the law. So what I hope to explain to you today is how to avoid the briar patch in the first place, what to do if you get thrown in, and then how to impeach experts at trial if you're absolutely required to do so. So we're going to identify the problems that arise. We're going to take a look at what the Bruen inquiry actually is, and does it even require expert testimony? We're going to look at ways of limiting expert opinion testimony through pleadings and evidentiary challenges, and then I will do a brief overview of the lawyers' ethical obligations in presenting expert opinion testimony in Second Amendment cases. So, a little longer exposition on what is the briar patch. Well, the briar patch, from my childhood memories, was refers to the ingenious defensive strategy of Brer Rabbit escaping Brer Fox and Brer Bear. The briar patch that we need to resolve, that we need to look at today, is the briar patch proposed by the interest balancing, judicial empowering tests that Justice Breyer proposed in all three cases: Heller, McDonald, and Bruen. I wrote about this in a law review article, "Navigating the Briar Patch." It can be found at the citation that you have here. I believe George is going to make available these slides in PDF format later, so don't worry about copying down citations, because I've included them all in the slides, and you'll have them. Okay, so what does the cartoon briar patch have in common with Justice Breyer's intermediate scrutiny briar patch? Well, Brer Rabbit's briar patch is a dark and mysterious place, and Justice Breyer's intermediate scrutiny briar patch is also a dark and mysterious place. Intermediate scrutiny appears nowhere in the Constitution, and wasn't something that was even developed until maybe mid 20th century by the Warren and Burger courts, to apply to unenumerated rights or ancillary rights, or somehow lesser protections of enumerated rights like commercial speech instead of pure speech. The Brer Rabbit's briar patch provides cover and concealment, and it's easy to get lost in. And comparing it to the Justice Breyer's patch, as we see from nearly every Second Amendment case that applied intermediate scrutiny, the Second Amendment was relegated to second place status, and at least in the Ninth Circuit, never won a case. Some interesting intra-circuit banter back and forth between the judges of the Ninth Circuit that the Second Amendment has a 0-50 win-loss record in that circuit, mostly based on the fact that the Ninth Circuit keeps applying some variation of intermediate scrutiny. Back to Brer Rabbit's briar patch, there are multiple exits once inside, and so it's easy for the court to wiggle out of absolutely uncontroversial evidence that you would be presenting. Okay, with a complex landscape that favors agility over strength. So no matter how strong your arguments are, a judge will always find a way to find that the government had a sufficient rationale, or whether or not the statute itself has even a loose fit to address the public policy. So what we run into is, if the government and anti-gun judges just switch from a criminological interest balancing test that we had prior to Bruen to simply balancing versions of history presented by history professors as experts, the problem remains the same. Meet the new boss, same as the old boss. And later on, we'll go over footnote 7 of Bruen on this very issue. So, for those who hate allegory, let me play this, your Saturday morning cartoon here for you.
Oh, there's no sound on. Is it supposed to be
There's
sound?
no sound.
No sound. or at least not for me.
And are the rest of the people not hearing sound either?
No sound.
No sound?
You have to turn up sound on your PC as well. Lower right corner with the little. Oh, you got a Mac. Never mind. But there's probably a master volume setting that has to be raised.
Can you hear it now?
In low volume.
All right. We'll just move to the next slide. You get the idea that Brer Rabbit doesn't want to be thrown in the briar patch, but it's actually to his, and he convinces his opponents that if they throw him in there, it'll be his undoing. When in fact, at the end of this, we can see that Brer Rabbit actually escapes the briar patch and goes on to commit other acts of mischief and mayhem. Sorry for the technical difficulties. Well, one of the ways to explain this is a case that I personally tried in front of an Eastern District judge in California called Sylvester versus Harris. This was a pre-Bruen, post-Chauvin case challenging California's 10-day waiting period. It was post-Chauvin, which means that the Ninth Circuit had developed the two-step rule for adjudicating Second Amendment claims, and at the time, it was the controlling law. Of course, the two-step approach was abrogated in Bruen, but it was how the court got to using this judge-empowering, intermediate scrutiny. At step one, is the Second Amendment implicated? If not, the claim's dismissed. If yes, does the claim implicate a core right? Then apply strict scrutiny, which almost never happened. But if yes, the claim implicated some non-core or ancillary right, then the court would apply intermediate scrutiny. And this is where we got into briar patch time, because the courts, especially the Ninth Circuit, never found any gun regulation that impacted any core Second Amendment rights. Now, this was after a 3-day trial where we took testimony. The court took literally thousands of pages of expert reports and studies. One of the things I would commend to you for understanding how this ends up being a briar patch is Justice Scalia's concurring opinion in McDonald versus City of Chicago. That case, the majority opinion or the plurality opinion found that the Second Amendment was incorporated against state action through the Due Process Clause. Justice Thomas concurred in the result, but wrote an entire concurring opinion on the Privileges and Immunities Clause. And Justice Scalia also wrote a concurring opinion that is often overlooked about the mischief that occurs when judges start applying their own standards as to what constitutes a fundamental right or whether or not a fundamental right gets infringed or not. So I commend to you the Justice Scalia's concurring opinion in McDonald for that as well. In the Sylvester case, California had two justifications for its 10-day waiting period. They needed to conduct background checks, and they wanted to prevent impulsive acts of violence. Well, the district court, after a 3-day trial, made factual findings. It struck down the 10-day waiting period. The government appealed. Now, the trial judge in this case was actually appointed by President Bill Clinton. So nominally he was a Democrat, but this was a judge who felt duty bound to apply as closely as possible the rule at that time, again pre-Bruen, to apply strict scrutiny in a meaningful way. Well, the Ninth Circuit reversed the trial court, and they did it by substituting their own factual findings for those of the trial judge. A petition for certiorari was filed with the United States Supreme Court, which was denied over Justice Thomas's dissent. Now, this dissent is remarkable in explaining what's the problem with intermediate scrutiny. Justice Thomas pointed out in his dissental that the Court of Appeals upheld the 10-day waiting period without requiring California even submit relevant evidence, without addressing the petitioner's arguments to the contrary, without acknowledging the district court's factual findings. And Justice Thomas pointed out that this is indistinguishable from rational basis review. And this is, in fact, what ended up happening in all intermediate scrutiny litigation, is that the courts just simply applied rational basis, but gave it the label of intermediate scrutiny. Justice Thomas then goes on to point out the other flaws in the circuit court's opinion. He even cites the rules that the Ninth Circuit were ended up violating. The Ninth Circuit was supposed to review findings for clear error. That's still the rule. And yet the Ninth Circuit still, without providing any explanation whatsoever, never explained why it had a definite and firm conviction that the trial court's conclusions of facts, findings of fact, were wrong. So this leads us to why Second Amendment litigators must be especially diligent in presenting evidence to the court that may, in fact, be interpreted by the court as either conflicting interpretations of underlying facts, which post Bruen is what is the status of the law during the founding generation. So we have this conundrum. If circuit courts are prepared to ignore and get away with ignoring inconvenient findings of fact from modern criminological data, what makes you think they won't manipulate findings based on history? Now, we're going to talk later about an opinion written by the late Judge Reinhardt from the Ninth Circuit, who earnestly believed that courts can and should be agents of social change. And when asked by a reporter back in 1997, wasn't he worried about being one of the most overturned judges by the U.S. Supreme Court? Judge Reinhardt's response was, they don't catch them all. And therein lies the hazard, ladies and gentlemen. If circuit courts are making errors of both law and now fact about laws from the founding era, those become ensconced and take on the perimeter of precedent. And once that happens, we are stuck with those rulings. For a previous article of mine documenting en banc abuses in Second Amendment cases in the Ninth Circuit, you can refer to the Firearm Research Center website for an article, Second Amendment Thoughts about en banc review in the Ninth Circuit, to show you the level of creative adjudication that we see from the Ninth Circuit to keep treating the Second Amendment as a second-class right. So what exactly is the Bruen inquiry? It's found at page 26 of the opinion. It's the purpose of the inquiry is for the court to determine whether the modern firearm regulation is consistent with the Second Amendment's text and historical understanding. The Supreme Court pointed out, and the bracketed term there is my comment, is that in most cases, in some cases, I believe in most cases, the inquiry is fairly straightforward. The Supreme Court went on to describe the three inquiries that are necessary. Laws addressing societal problems that have persisted since the 19th century. And then there was a means inquiry to compare how those problems were solved then and now, and then whether any of the means were rejected on other constitutional grounds. And we'll take a deep dive into those now. But what is not part of the Bruen inquiry, the court said nothing about conducting a scavenger hunt through old statute books for the terms gun, gunpowder, rifle, rod, sword, knife, arms, cannon, okay? Which is what appears to be happening in some of these district court cases where the government's experts are coming up with statutes that they believe are relevant simply because they mention the word gun. The Supreme Court also said nothing about doing architectural or landscape comparisons of public spaces from today, libraries, parks, museums, zoos and taverns with public spaces from the 18th century. The case that's currently before the Supreme Court right now, Wolford versus Lopez or Wolford versus Hawaii, is dealing with this very issue, where the state of Hawaii was trying to declare all manner of places sensitive, and doing so by trying to compare the analogs of sensitive places from the 18th century with their analog in the 20th century. But that's not the analysis. The analysis is the law that was intended to address a persistent problem or social problem. The court said nothing also about comparing the lethality of born arms today with born arms from the 18th century, and of course that's going to be relevant as we get into the AR-15 and semi-automatic cases that are winding their way up to the U.S. Supreme Court. So Bruen inquiry number one, and this is a quote from the Bruen decision. Does the challenged regulation address a general societal problem that has persisted since the 18th century, and whether or not, and so the focus is on what was the societal problem. The first inquiry is not a comparison between two old laws and that regulated arms, but between the laws addressing the persistent problems. When it comes to self-defense, that breaks down into two sub-inquiries. Were the founders aware that assault, battery, mayhem, murder, violence, basically public violence, occurred, thus necessitating armed self-defense as the first line of public safety? And then what remedies did the founding generation implement to address those problems? Did they enact gun-free zones? Did they place limitations on weapon technology? Or did they disarm dangerous people? I will see later that Rahimi, which followed Bruen, basically directs us to take a look at that third alternative, disarming dangerous people after an appropriate inquiry. The second Bruen inquiry is, did the earlier generation address the societal problems through materially different means? And if yes, that could also be evidence that the modern regulation is unconstitutional. In asking how the founding generation addressed their social problems, though, it's requiring an analysis of means for addressing the problem, not the means of self-defense. First, merely passing laws, banning them in sensitive places is not a materially different means. The founding generation had access to legislatures. They could pass all the laws banning things that they wanted to, yet they did not pursue that means for addressing public violence. Continuing on with the second Bruen inquiry, what the second inquiry had in mind, and as illustrated by post-Bruen decision in Rahimi, is that when Rahimi found that peace bonds from the 18th century, after a particularized finding of dangerousness with varying degrees of due process, was not materially different from modern order of protection laws, which also have their own varying degrees of due process. Of course, in the Rahimi case, the Supreme Court did not expound on, except to note on what process is due, except to note that Mr. Rahimi's due process rights were not violated, that he in fact had notice and an opportunity to be heard on his order of protection. So this is the kind of means testing that the court was encouraging legislatures and courts to do on the ways in which the ancient or the founding generation and the modern generation is dealing with the societal problem, not with how to limit or otherwise hamper the right of self-defense. And finally, the last part of Bruen inquiry number two Again, are there materially different means, even nuanced approaches for dealing with societal problems? Is is to point out how metal detectors and X-ray machines permit the creation of actual gun-free zones in the limited environs of, for instance, airports and courthouses. But these places are unique precisely because they have limited or singular points of entry. So if governments want to ban guns in so-called sensitive places to enhance public safety, they should also be compelled to control the ingress and egress from those places using the examples of courthouses and airport terminals. So that's the kind of nuanced approach that the court was referring to when talking about um, um, you know any differences that exist between the founding generation and now. The last Bruen inquiry, which is also at issue in the Wolford case, is whether or not the founding generation remedies have since been rejected on other constitutional grounds. Now, in this instance, what we're looking at is does the this inquiry addresses, of course, the slavery laws and the black codes. So, to the extent that governments and lower courts are relying on ancient laws derived from the black codes, banning Saturday night specials, for example, or imposing wealth requirements on having a firearm, those are not a valid ancient law to cite to the court for the proposition that guns can be banned by certain classes of people or in certain places. Okay. The Of course, the solution to persistent societal problems of race-based violence is not to disarm one race or the other, but to simply enforce the 14th Amendment. So the Bruen inquiry is not a license to grant modern gun laws immunity from a Second Amendment challenge based on some historian's opinion about the differences or similarities between the 18th century and the 21st century. Okay. It does not matter how much a library from 1800 is like or not like a library in 2025, or for that matter, how much a Kentucky long rifle is like or not alike an AR-15. The Bruen inquiry is to determine whether the social problem has persisted into modern times from the 18th century, and that inquiry is straightforward. And it's this simply: is there still a risk today of being unarmed in a confrontation with an armed criminal or a rogue tyrannical government? The Bruen endgame. Okay, this is what we do all this work to get to a the a the purpose of the analysis. Three times now, the Supreme Court has ruled that the individual self-defense is the central component of the Second Amendment right. Therefore, whether modern and historical regulations impose a comparable burden on the right, the burden is comparably justified. The analogical inquiry is to be comparing the right of self-defense. Here are your citations to this quote that appears in all three cases. So then we get to the overlooked footnote 7 and the whole point of this lecture. The Supreme Court has already told us that it does not mean that this Bruen inquiry is that courts may not engage in independent means end scrutiny or judicial empowering intermediate scrutiny under the guise of an analytical inquiry. Okay, it requires judges to faithfully apply founding generation to modern circumstances. It is not an invitation to revise the intermediate scrutiny balancing test of criminological data for just selecting which historian you believe and which historian is more credible. And again, that the citation there is to Bruen at page 29 of the. So this gets us to is there a place for experts in the Bruen inquiry? The short answer is yes. Um, the longer answer is yes, especially if the government merely tenders exhibits of old statutes, because despite rules of professional conduct and rules of civil procedure, it's surprising how much false, uh, perhaps mistaken, perhaps out of negligence or sloppy research, how much bad citations end up in front of courts. This is why, as I'm going to be introducing Clayton in a minute, why a consulting expert is invaluable in doing the work of Second Amendment litigation when it comes to comparing these societal problems from the founding generation and their approach to fixing the problem and how that impacts Second Amendment rights in modern times. The cumulative complete answer is yes, because in addition to ferreting out false citations and mistaken citations and incomplete citations and wrong citations, is you're going to run into the situation where the government, as I have in a case right now, designates 13 expert witnesses to opine on everything from how an 18th century library is different from a 21st century library, or how playgrounds didn't exist in the founding generation, or that museums are somehow different, or that taverns are somehow different. You will need an expert witness to both help you attack the expert, but also to impeach the government's expert if the case has to go to trial. So at this point in time, I'd like to introduce, a dear friend who I've known for 20 plus years, and a man who with unparalleled integrity, in my humble opinion, on Second Amendment historical research. Clayton Cramer has been cited by the U.S. Supreme Court in the District of Columbia and McDonald. He was even cited by the dissent in McDonald, and I provided you here with the citations. But one of the things that makes Clayton particularly invaluable as an expert is his work in exposing the academic fraud of one Michael Belle-Isle, a professor of history at Emory University, who wrote a book called Arming America back around the turn of the century. The thesis of the book was that firearms were not prevalent or even popular during the founding era. The book actually won the prestigious Bancroft Award for significant contributions to historical writings on American history. The book's value was so lauded and put forth as definitive or authoritative. It was actually cited by the Ninth Circuit in a case called Silvera versus Lockyer. However, due in large part to Mr. Cramer's work, after the academic fraud of Michael Belle-Isle was exposed, the court had to issue a correction to its opinion and delete all references to Mr. Belle-Isle's work to that Ninth Circuit opinion. So, without further ado, I'd like to introduce Clayton, and I think I have to stop sharing.
Thank you. Let me go ahead and share my PowerPoint here. Okay, so you're able to see that. Now, amazingly enough, I seldom need to actually pursue the logic errors in the expert testimony of historians. It's actually often much easier than that. First of all, first step is looking up the laws that are cited by both the state and the experts and seeing if those laws actually exist or not, and then finding out were these laws that were actually passed. Are these laws that Bruen considered and rejected? Then looking to see if the laws have been misquoted, quoted very carefully. And then occasionally I have to actually use expert knowledge that I've developed over the last 30 years of studying this topic in a way that that there are people usually cannot. Hang on. Why is this not letting me? Okay. So surprisingly often, both the expert and the state will cite a law that is not there, or at least not the law that they claim is there. Here's an example. This came out of a case called Baird v. Bonta. They cited a number of laws which they said uh, prohibited riding armed by night or by day. And they list some of these. One of these is a 1786 Virginia law, Acts 33, chapter 2021, which you can see over here on the right side of the screen. You can see an act for giving further time to officers, soldiers, sailors, and Marines to settle their arrears of pay and depreciation. Obviously, it's nothing to do with guns. They cited Massachusetts law from 1795, which an act to change the name of William Sheldon, again, has nothing to do with their claim. They cite a Maine law that from 1821, which again you can see the pay. There is no page 285 in that session law collection, and Chapter 76, as you can see, has absolutely nothing to do with guns at all. There's a 1795 Massachusetts law that I've mentioned here. It turns out I've spent an awful lot of time chasing down all the claims they've made. Each time I point out this isn't there, they come up with a new explanation, none of which work. I could spend hours explaining all the areas where I pursued their errors on that. So I'm not terribly familiar with why is this not sure? I'm trying to figure out how to get this thing to skip forward.
Just advance as you normally
Yeah.
do.
Here it is. Session laws that were never passed. One of these things that is repeatedly referenced in multiple declarations from experts in many different cases is this thing that looks like a session law, at least it's cited like one, 1792 NC Law 60, Chapter 3. Problem is that when you actually go to find the document they're talking about, it is not a session law at all. It's a collection of statutes of England that the North Carolina legislature had asked this lawyer named Xavier Martin to go through the old English law, see are there any of them that are still relevant, still in effect in North Carolina today. They basically went through and said, well, I went through and I found all the old laws. I've inserted every statute unrepealed by subsequent acts or which did not appear so glaringly repugnant to our system of government as to warrant its suppression. So basically, any law that might still have some relevance, he thought. So then we actually look at the law that's at page 60 to 61. Here you can see that it refers to the king's servants. This is the 1328 statute of Northampton that the Supreme Court in Bruen specifically rejected as irrelevant. And of course, the fact that it refers to the king's servants shows that this was not a law passed in 1792 by the North Carolina legislature. Come on, there. So there's a number of cases also where the experts of the states cite laws that Bruen examined and specifically rejected as irrelevant. For example, peace bond laws are referenced in many places. These are laws that peace bond laws allowed judges to that if if Mr. A complained that he regarded himself as being in danger from Mr. B, the judge could require Mr. B to post a bond for keeping the peace. But interestingly enough, even though the law required him to post a bond, it did not prohibit him from carrying a weapon. Nor was there anything about the bearing of a weapon that constituted a violation of the requirements of the bond. So these are laws that are completely irrelevant. The Supreme Court has already said are irrelevant, and yet the experts keep citing these. The states keep citing them. There's also another example of a 1686 New Jersey law that, again, was specifically examined and rejected as irrelevant to this question in Bruen. And of course, they continue to go ahead and cite these. And then, as I mentioned, there's the power of careful misquotation. One of these is a declaration by Bruen and Rivas, again in a case called Baird v. Becerra, which was basically a follow-on to Baird v. Bonta. Basically, she's listing laws, as she says, were laws prohibiting the carrying of knives in public places. So the next step is to go and actually look at the law in question. The 1846 law, the things that got left out with her careful quotation is that the law specifically bans the carrying of arms secretly or on or about their person, and then goes on at the end to say, this law shall not be so construed as to prevent any person from carrying arms openly outside of all their clothes. So in her attempt to justify that this was a general ban on the carrying of knives, that just is not supported by the actual law itself. Some of the 1838 laws, she again quotes just bits and pieces of, goes on to make the point that this law will not apply unless the knife is hidden or concealed from common observation. The other thing is, there are times that actual expert knowledge is kind of important. For example, their experts often lack knowledge of what the word gun means. Throughout the 19th century, gun meant something rather different than it does today, in both dictionaries and in common usage. Here are a couple of examples from two dictionaries of the 19th century that both show that a pistol is never called a gun. So gun refers to cannons, it refers to long guns, but it never refers to a pistol. Of course, why does this matter? The reason it matters is that their experts often cite both laws and, in some cases, institutional rules that, for example, railroads had regulating the carrying of firearms by guns by passengers to justify current bans on possession of firearms on mass transit of any sort. Another example that I actually had rather fun with. Some years back, there was a case challenging the California Unsafe Handguns Act. This was a law that imposed a rather unusual, non-standard safety tests for handguns, theoretically to make handguns sold in California safer, but really it was to make handguns pretty much impossible to sell there. To justify this, their expert, Saul Cornell, who has a PhD in history, pointed to a gun-proofing law in 1814 in Massachusetts. Gun-proofing laws were laws that required a gun to be fired with some sort of excess powder charge to make sure it did not explode or otherwise endanger the person who was firing it. His argument was that Massachusetts was the center of the firearms industry at the time, and therefore this shows this was clearly considered an acceptable law by the framing period. So I pulled out the census of manufacturers of 1810 and of 1820. You didn't know that the federal government did a census of manufacturing in those years? Well, you've got a good excuse. You're not an expert. But the 1810 census showed no gun makers in Massachusetts. There are gunsmiths, but no one making guns. The 1820 census of manufacturers is not quite as elegant as this. and how it's organized. But again, the only manufacturer was the one manufacturer who was excluded from this law, and that was the national government's arsenal at Springfield in Massachusetts. So, not surprising, we won that case at trial. Now, how do I demonstrate to the court that I know what I'm doing, or the judge or the law clerk, who is actually the one who's going to be checking all this stuff, I hope? As an example, Professor Spitzer, one of his expert declarations, was arguing that there's a long history of prohibiting people from possessing guns while drinking or drunk. And as one of that list of laws, he points to a 1750 law from Pennsylvania. The title says, "For suppressing idleness, drunkenness, and other debaucheries." However, when you actually look up the law, you find that it prohibits the firing of guns in towns, and this is a part of a list of things that are basically fire suppression matters. For example, it prohibits setting fire to your chimneys to clean them out. And they're telling there about firearms and alcohol. What there is there is a prohibition on the selling of rum, wine, or other strong liquors at auctions. And then just to make sure that the judge or the law clerk can actually verify this, I include a link so they can click on this and have it bring up a copy of the session law. Because it turns out pretty much all the session laws you can name for all the period of the 19th century and 18th century are actually available online. You can actually see the session law. You don't have to rely on someone else's image of it or copy of it. So anyway, that's what I do as part of my effort to deal with these experts who in many cases are not all that terribly expert. Well, thank you. Go ahead and see about unsharing this.
Okay, I think that's my cue to resume my lecture here.
Okay.
George, I think you need to give me back the ability to share. Oh, there we go. This brings us to what are a lawyer's duties in presenting expert testimony to the court for a Bruen inquiry. The ABA Rule of Professional Conduct 3.3a requires a duty of candor to the tribunal. A lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. A lawyer shall not knowingly fail to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position his client of the client and not disclosed by opposing counsel. So theoretically, if I fail to present a law, the government's lawyer knows of an opposing law, I don't see any exception for ancient laws that are being cited for making constitutional law arguments, that he has a duty to disclose that. So that gets into, for example, as Mr. Cramer was pointing out, are there instances within these laws that are being cited that take the exact opposite position? For example, that the prohibition on carrying knives that was attempting to be cited for a control on arms only applied to the arms that were concealed carried. So this is where a lawyer is violating his ethical duty if he fails to disclose the entire law. A lawyer shall also not knowingly offer evidence that the lawyer knows to be false. And this gets us into a conundrum that I think is actually resolved in the comments to this this model rule, and also in the Federal Rules of Civil Procedure. Does the lawyer have a duty to investigate In other words, is it enough for a lawyer to simply say, "Well, this is my expert's report," and and not review it himself, especially when we're asking these experts to submit ancient laws and statutes to the court, when really it's the lawyer's job to present ancient statutes, laws, and valid regulations to the court. So the lawyer can't push that duty off onto his expert, and then if it turns out later, as an expert with the talent of Mr. Cramer points out that this is not what the law says, and then say, "Oh well, sorry, Your Honor, my bad. I'll take a mulligan on that." No, if you have presented a false statement of the law to the court, you have breached your duty of candor to the court. Let's take a look at two other subsections of Model Rule of Professional Conduct, subsection B and C. A lawyer also who represents a client in a proceeding also has a duty to take reasonable steps to make sure that they aren't presenting false testimony to the court. So again, it's not enough for the lawyer to simply say, I need experts to give me cover on what we want this law to say in order to uphold the law. The lawyer has a duty, an affirmative duty, to check those citations himself. And also, the duties stated in paragraph A and B continue to the conclusion of the proceeding, which arguably means, that if the court issues a decision based upon a false a statement of law or a false citation or a false interpretation of an ancient law, the lawyer that presented that evidence has a duty to disclose it and to seek a correction. And here are to back that up. Here are some of the comments from the ABA model rule on the duty of candor towards a tribunal. So from comment 2, the lawyer must not allow the tribunal to be misled. That's the essence of the rule. Okay. So tactical and strategic considerations aside, it is a breach of your duty of professional responsibility to allow the court to be misled by your own expert. And here's where we get in reading the comment that the lawyer in fact does have a duty of reasonably diligent inquiry, and really that it's not rocket science to come to that conclusion. If you're presenting ancient laws to the court in the guise of an expert's report, rather than just simply citing to the law yourself in your brief, you have as much duty to make sure that your expert's opinion or your expert's report is based on what the law actually says, as you would if you were putting it in your own brief with your own signature above it. Let's see here. And then finally, the duty to disclose directly adverse authority in the controlling jurisdiction, that even if it has not been disclosed by the opposing party. We also are bound by the Federal Rule of Civil Procedure 11B, subsections 3 and 4. In maybe making representations to the court by presenting pleadings, written motions, or other papers, the material presented to the court must be accurate, and it must be after you have done your own inquiry that would be reasonable under the circumstances. I don't know of any court or any bar inquiry that would say that a lawyer does not have that it's not reasonable to inquire if the ancient laws they are presenting to the court as part of an expert's report weren't also cite checked by the lawyer himself. So again, subsection 3 reiterates that there must be, now maybe there is some excuse for some sloppiness during preliminary injunction litigation or temporary restraining order litigation. But even even after an opportunity for further investigation or discovery, if you discover that your expert has submitted a misleading or mistaken quote to ancient law after the interlocutory litigation, during the litigation on the merits, you're going to have a duty to correct that, which can be devastating to your case, but it is your duty nonetheless. Again, reasonably based on a belief or lack of information, uh, further supporting the idea that the lawyer has a duty to do his own independent investigation of the expert testimony that is being presented, either in declarations or in live testimony. Now, getting to the nuts and bolts of actually presenting expert testimony, if you haven't picked up on the motif by now, the the probably preferred practice is to keep your expert as a consulting expert, which is easy to do if you're plaintiff's counsel, because the burden is on the government to produce these ancient statutes. And usually your discovery scheduling orders allow you to make a decision after receiving opposing counsel's expert disclosure, whether or not you're going to hire an expert. But even if the other side doesn't disclose an expert, you'd probably still be worthwhile to hire somebody like Mr. Cramer to check the citations that the lawyer has made, because you won't know if the other side is using a consulting expert without disclosing them as a testimonial or trial expert. So expert testimony is admissible if the proponent of the evidence can establish, one, that the evidence is based on a reliable foundation. Okay. Among the other indices of reliability, and there are a ton of them, the expert must apply the principles and methods of his or her field of expertise to the facts of the case. Now, what facts are there in Second Amendment litigation post Bruen that need to be applied? And it's the similarity or dissimilarity of founding era laws to modern era laws. It may or may not be appropriate to have an expert opine on that. It probably is inappropriate, in fact. That's the judge's job. It's the lawyer's job to present the arguments and the laws as a historical artifact, but it is not the expert's job to explain to the judge why an ancient statute might be similar to a modern statute. The other thing that makes expert testimony admissible is whether the evidence will assist the trier of fact. Don't overlook this, folks. Is the other side presenting facts or the law? If the sum and substance of the expert's report is, here's this statute from 1804, and it's similar enough to a statute that was passed in 2024 that you ought to uphold the modern statute, that doesn't require expert testimony. That so you should seek to actually exclude that kind of expert testimony on grounds of relevance. Which gets us to, how do you get this stuff excluded? And it is it's through a Daubert motion. It's critical during discovery to establish a record for your Daubert motion. You have to analyze the other side's report for factual inaccuracies. Do that first, okay? Then once you have made your own notes and your own thoughts and impressions, preferably with a written legal memo, that is then you hand off the expert's reports and your thoughts and conclusions to your expert, somebody like Mr. Cramer, and you confer with your expert about the weaknesses of the report, and then you turn your expert loose to hopefully wreak havoc with the other side's expert. You're going to want to identify precise testimony that is subject to a motion to strike or a motion to exclude. You may need to take the deposition of the other side's expert, focusing on their methodology. One way to prove that their methodology is poor or flawed is to demonstrate, for instance, through the work of somebody like Mr. Cramer, how the citations were not accurate. They were citing the laws that didn't exist, or they were citing the laws that were completely misnamed or misleading. The last part is to apply the methodology of the contested facts of the case. Again, this is where you go back and take a look at the Bruen inquiry and see whether or not the expert is actually providing factual evidence, because that's what an expert report is for. The expert is not there to opine on the law. The expert there is there to opine on the facts. And are the facts being presented? Here's this law from 1804. Is an expert's testimony necessary to resolve any contested issue of fact about what that law says, not what the law means? The standard of review for a Daubert motion is that a Daubert motion will be upheld unless the appellant shows both an abuse of discretion, which can be shown one of two ways: either clear error of judgment by your trial judge, or that the judge applied an incorrect legal standard. This is where you will do most of your work in your Daubert motion to lay the foundation for appeal, so that you can demonstrate clear error. You're sort of playing an advance game here with the trial court to make sure that you're preserving the error so that you can argue it to the appellate court. But then you must also show actual prejudice. Okay, so if you are dealing with a hostile court, or you anticipate a hostile appellate court, your task is to make a record that can be used to extract you from the briar patch. Two last points, somewhat controversial. I said earlier that there may be things that you need to do in the pleading stage in order to stay out of the briar patch. One of those is never waive a jury trial in a case in which the Bruen analysis is going to have to be done. It may sound counterintuitive, because here I've been telling you that these aren't disputes of fact, they're disputes of law. You can always waive the jury later, but you can't invoke a request for a jury trial later on in the process. So in the pleading stage of your case, demand a jury trial. You can always waive it later. Because if the case is going to end up turning on a credibility contest between your expert and the government's experts, credibility determinations should be made by juries, not judges sitting alone. And there are provisions in the federal rules of civil procedure for judges to have what are called advisory juries to assess the credibility of witnesses, even though the judge reserves the power to make the ultimate determination on what is admissible and what is not admissible. Finally, there's the old saw that lawyers are often taught in law school and by senior partners once they become associates and mid-level lawyers: never take on the other side's expert in court. This may be one instance where you can disregard that old rule of thumb, because in the final analysis, whether a law from 1804 is similar to a law to 2024 is a question of law, and you are a lawyer and you are an expert on the law, even though the judge gets the final say on whether the law is relevant or not. So don't be afraid to cross-examine the other side's expert if they are presuming to opine on the meaning of a law from 1804. This is probably this is about the only way that you're going to be able to try and stay out of the briar patch. Thank you for allowing me to present this to you.
Great.
Thank you.
Thank you, Don. Thank you, Clayton. I've got two questions here. We're a bit over time, but everyone is welcome to stay and listen to the two questions. The first one is um, just quoting here. I've read Clayton's reference and Bruen, and I have a question about the founding era. How can SCOTUS, excuse me, seemingly end the founding era in 1791 as Bruen seems to do? It seems to me that we started this country with $4.7 million in debt, of which 3.5 million is attributed to the Militia Act of 1792, question mark there. Um, it seems that Bruen ignores the act and its impact on the Second Amendment and the early gun culture in the USA, question mark.
Well, I would say, first of all, the 1791 date is because that's when the Second Amendment is ratified by the states, and the to a large extent, the Supreme Court has worked on the theory that if look at the laws that were in effect when, for example, the 14th Amendment was ratified in 1868, or when the Constitution the Bill of Rights was ratified. They've used that to say, okay, well, this is what laws were in effect at that point in time. It's a pretty good guess that that is what was understood by the states when they ratified that amendment, what this meant. And also, I'm not sure where that expense for the Militia Act of 1792 comes from. The Militia Act of 1792 did not actually do much in the way of expenditures. It imposed a requirement on individuals to go out and possess a militia arm appropriate to military duty, but there was no actual cost to the U.S. government to do that. That was a cost imposed on the individual militia members, which is again, this is a follow-on of the sort of laws that were already in wide effect throughout all the colonies except for Pennsylvania before 1791, requiring individual militia members to possess military arms.
One other comment, follow-up comment to that is that there is an extensive discussion in the McDonald case, which of course dealt with incorporation of the Second Amendment, where there was an attempt by the dissent to say to have this discussion about, well, oh yeah, the Second Amendment was written or ratified in 1791, but 14th Amendment was written and ratified in 1868. So what Second Amendment are we applying? And I believe that there's a discussion in the McDonald opinion that the Second Amendment that applies to the federal government is the same Second Amendment that applies to the state. And from that, we could draw a strong inference that that means that the 14th Amendment is incorporating a Second Amendment that was as it was understood at the time it was ratified.
Yeah, I think that's correct what Don just said. It's kind of an the 1791-1868 question looked like it was settled in McDonald, which said yes, it's 1791. But then Bruen and Rahimi said, well, maybe it's an open question. Clayton and I, with another co-author, actually wrote an article in which we talked about this that was cited in McDonald, and there are good reasons to think that 1868 should matter, but at the moment it seems like it's an open question, and the reason the court hasn't decided is that it said it didn't need to decide because the answer is the same in Bruen and Rahimi whether we look at 1791 or 1868. So one more question. Quote, Rahimi addresses the defendant after having a hearing on his prohibition. What steps can we take, excuse me, what steps can we take to challenge the removal of firearms during a civil protection order process where the defendant is stripped of their firearms prior to being afforded the ability to defend themselves in a courtroom? Example is the Pennsylvania PFA system, removing firearms upon the word of a plaintiff prior to any hearing in which the accused has the ability to defend.
This sounds more like a due process question than a straight up Second Amendment question. But having done a lot of litigation in with regard to suspension of firearm rights pending a mental health determination or a domestic violence allegation, there are. I mean, you probably post Bruen and even post Rahimi, you it's not not frivolous to request you know, some kind of assurance from the court that that your client won't be the disarmed victim going forward, and how the court wants to resolve that or handle that. Um, I don't know. The family courts are empowered to fashion all kinds of remedies in order to implement their orders. So you could imagine that the court would say, well, if you want an order of protection against somebody who you claim has been violent towards you, perhaps you should pay for them to stay in an anonymous hotel somewhere until the hearing, so that they're not a victim of violence while their guns are being held by the police department. So it has almost the effect of requiring the person seeking the order to post some kind of bond, but it really wouldn't be a bond. It would be, look, you're asking the court for an extraordinary remedy. You need to be prepared to back your claim up, because too often we see that what happens is, especially in high conflict divorce cases, these allegations of domestic violence sometimes, certainly not all, are simply litigation tactics. They have nothing to do with any actual allegation of violence.
Great. So with that, we're almost 15 minutes over. We did get a question earlier. One point on this, there is a video on red flag laws in our video library. If you go to firearmsresearchcenter.org, hover over the resources tab and go down to video library, it's there. That might be helpful to this last question. It was given by Jonathan Goldstein, and that was another CLE, and it's still available for CLE credit, for video credit. He's a Pennsylvania attorney who is quite knowledgeable about the space, so I'm happy to make that introduction if that would be helpful. This slide deck will be on the website on the events page from which you registered. Clayton, if you're willing to share your slide deck, I'll put that one
Sure.
there as
Go
well.
ahead.
The recording will also go into our video library. The slide decks should be up in about a week or so. The recording typically takes just a little bit longer to get up onto the website, especially with the holidays coming up. But it will be up there, and it will be eligible for self-study video credit CLE when it's there.
And I apologize to everyone for not being able to get my cartoon to work.
There you are. And just note, everyone, if you're sharing this with someone, it is eligible for a quarter hour of ethics CLE credit, thanks to Don's diligence in presenting that aspect of it. So with that, we'll cut it off here. Thanks everyone who stayed late for staying, and we look forward to seeing you at our next video seminar. Have a very Merry Christmas or whatever your holiday is, and a very Happy New Year. Thanks, everyone.